use there. But anyway, I'll start. For those of you, you all know me, I'm Rosa, and I run a little practice here in Bendigo called WR Law, and it specialises in employment law. So I do everything in employment law, except I have got great enterprise agreements, but I think I've got Pauline there who's going to help me at some point in my life with enterprise agreements, so that's good. And Carol's there as well, who can help me as well. What I do with this once a month session now is I partner with a local business, usually food and hospitality or wine. We've just had winemakers in recent times, and I continue that tradition by introducing the wonderful Tim Robertson, who is the winemaker at Lome, and he's also a fellow lawyer in town. So I'm going to hand over to Tim to talk about, he's brought two lovely wines today. And he's going to talk about both those wines, and I'm going to have a sip on them while he talks about them.
Thank you, Rosa. Well, our vineyard Lome is at Harcourt, which is southeast of Bendigo, near Castlemaine, I guess. It's probably where most people would understand. And the aspect about our vineyard which we think is unique is it's on the granite country, which is the old granite soil, which is very appropriate for vineyards, and we are growing Rhone style wines there. In some respects, mirroring the sort of varieties that you would find in the Rhone Valley in France, and the sort of topography and climate. So, Rosa, I thought we should start perhaps with the white.
I can't wait. I've been holding on all day waiting for you to arrive.
This is our 2017 Viognier Marsanne Roussanne. So it's a traditional Rhone Valley blend, and we should perhaps have a taste, and then we can talk about the wine itself.
Cheers. Santé. Santé.
Good health. Yeah.
How did you come to be interested in wines from the Rhone Valley region? What piqued your interest in that?
I had been growing grapes in my backyard when we lived in Bendigo many years ago, and it's one of those hobbies that got a bit out of control, and I eventually bought a paddock and started a vineyard.
Like my husband, he planted 3 trees, and next thing he planted 14,000 trees. So I sort of got a bit out of control. That is really beautiful.
Thank you. So the Viognier gives it an aromatic character, and the Marsanne is more of a herbal character, and the Roussanne is more floral. So what we're trying to do, I suppose, is to achieve some of the characters of each in a combination, which is really the sort of wine that you would have with things like cheese and fish, and it's quite versatile.
It's very aromatic. It's beautiful.
Yeah. So it's not a sort of a fresh or crisp wine, but it's more of a savoury style.
It's very smooth.
Yeah. Thank you.
And so, how long have you had the actual vineyard now then in Harcourt?
This is our 13th season.
Wow.
Yeah.
And you supply a few other wineries around with grapes.
We still sell grapes to other local vineyards, and we make about half the crop we make wine from. And
how does law fit into all of this? It sort of fits around your winery?
Well, it's been there have been so many weekends devoted to the vineyard. I'm truly lost count, but it's now more established, so it's a little bit easier to manage, and I find that it actually works quite well in a COVID situation. I can duck out in the morning and do a few tasks, and the same in the evening, and I work during the day in front of my laptop. So it's a nice mix, really. I mean, the appeal for the vineyard for me is that it's outdoors and it's a little bit of horticulture, farming, and
very relaxing as well,
yes,
I imagine.
I find it's really appealing. So a lot of history in the wine industry in Bendigo, and
it's a fabulous region. That's why I wanted to do it. I thought, what better way, particularly before we get back into stage 3, to support local businesses, those ones who've been decimated the most in the hospitality field, to and I love, if people who know me know I love a glass of red or two and white, to bring both together. And the whole point was that, you know, laws are changing so rapidly, particularly during COVID. It's almost impossible to keep up. It's hard for me to keep up, and I'm sitting in front of my laptop every day doing it, let alone business owners and HR managers. So I thought it'd be a lovely chance to sit down at the end of the week. I was doing it initially, you know, weekly, fortnightly, and to have a glass of wine. I used to have a bit of a platter of cheese, and we could just sort of, you know, have a little bit of a chat about the cases. So that's how the whole idea came about, and it's been going gangbusters. It's just been, people have been really supportive and loving it. You might have a bit of a go of your red. Do we need some more? I've got some glasses behind us.
okay.
The smell is just...
Okay.
My husband's a Shiraz nut, so maybe he'll try the Shiraz. And you're not open at the moment. Are people doing, you're doing cellar door at all? People can come there at all or not?
Not at the moment, but we expect that the planning permit application that we're making will be approved very shortly. And is there a few more?
Oh, no, you have. We'll share one, Mum. You have that one.
Okay.
My husband loves it more than me.
Plastic.
Thank you. Cheers. We'll do the cheers, then you can drink the rest of it. Oh, it smells divine.
So,
Oh, that's divine.
Rosa, Shiraz is a real staple in the Bendigo wine region, and what do you expect from a Shiraz here? Well, this is, to some extent, I have a sort of modern interpretation of the tradition. It's an earlier pick style. It has 18 months in old French oak before it's bottled, and we're trying to preserve that freshness and have a wine which is slightly lower in alcohol and has a vibrancy about it, so that it's a good wine.
It doesn't feel as heavy as a lot of Shirazes either.
It's a bit lighter, I think, lighter and brighter, and that's the message we have for many of the restaurants in particular.
So on that point, where can you get your wine in town?
Well, talking of restaurants, you can buy it at Mason's.
Lovely, of course.
A very nice restaurant here in Bendigo. At Wine Bank on View.
Yes, again, a lovely venue in Bendigo.
And also at Harvest in the View Street.
Very nice.
Harvest Cafe. And we sell wines down the Calder corridor into Melbourne as well.
Okay.
Quite a lot of it in the local district.
And you'll see on the screen, if you can see the screen there, that the Bress logo is there as well, because of course Tim is half owner of Bress, along with Chris McCormick, who came along a few weeks ago and talked to us about some of the beautiful Bress wines. So I think Tim has certainly moved a bit beyond the whole legal world, and is what do you call a winemaker? A Viognier? Is that what you call it? A vigneron. Anyway, he's a winemaker now rather than a lawyer.
I think that's probably the transition I'm making, is to spend more time in the vineyard. So Bress is a wonderful brand, and has been established for almost 20 years, quite close to where Lome is. And the owner, Adam Marks, has retired and gone to Queensland, and so Chris and I have bought the label and the business to keep it local and to have the benefit of that pretty substantial goodwill and the particular styles of wines which have been made under that brand for a long time.
I think Greece is one of the iconic wines of the region, really.
We think it's compatible with Lome because Greece really focuses on Burgundy styles, Chardonnay and Pinot Noir. And
I
with
love
Lome,
Pinot with Greece.
with Lome, we're doing more Rhone styles such as the Shiraz and this white pudding.
But I know Tim has moved on from law because very cheekily the other day when I was talking to him, I said, will you come and open a law practice with me? And he said, no. He said, I think I'm more of a winemaker these days. So anyway, on that note, let's go and talk about a couple of cases. Chin chin, we're doing a chin chin. We're going to look at the camera. Right, I'll go back a little bit. Let me go back a little bit. I wanted to talk a little bit about who I am. Most of you, of course, know who I am. I've worked in this space, and although I've got very youthful skin, it's probably about 30 years now, either as an HR person, an employee relations person, and a lawyer. And I've worked in-house as a lawyer. I've worked for a national firm, and there's not much I haven't done. Employment law is my passion, hence why I do these sorts of things. I also do a whole lot of other things. I do something called Legally Speaking, which is geared towards employees, because I think employees need to know their legal rights as well. So I do one for employers and one for employees. I do employer seminars across Victoria. I'm doing some in Wodonga next week, and Albury, and in Sunbury. So this is really what I love, and I think that's always a good thing to get your advice from someone who loves what they do. What do I do? Well, pretty much I do everything in the employment space, from hiring to firing, I could say, and everything in between. The only thing I don't do a lot of is enterprise agreements, as I said, but I'm getting better at those. I've got a lot of excellent people on hand to help me, i.e. Pauline and Carol. So, but I could, I do everything: unfair dismissal, adverse action, discrimination. I've got 3 cases in the federal court at the moment, so I'm doing much more litigation. I do policies, employment contracts. I can advise you on anything. I mean, probably my sweet spot really is the whole employee relationship, as in someone who is inside the your business. They're ill or injured, that's probably my best strength, for ill and injured workers. I don't know how I've managed to get to that, but and redundancies. Today I'm going to talk about a few things. It looks like a lot of things, but it's pretty quick. There's a few cases that I think are pretty interesting. There's one, lately I've been banging on a lot about redundancies, because the Fair Work Commission has been really taking a very close look at redundancies and how people are made redundant. There's been a lot of cases. I've talked about a few of them. One I'm going to talk about again. I talked about it last time, but I think it's interesting. And there's another one. But I want to move away from JobKeeper and that whole world, and also talk about something else that's I've been working on these last few weeks, which is restrained trade, which I think is really interesting. I've learned a lot in the last few weeks about restrained trade, because I'm also doing the accreditation to become an accredited specialist. And so I'm studying a lot on weekends, and I learned a few things. As all of you would know, I assume at this point, JobKeeper has been extended. It is a bit different to what it was. Obviously, because it got rushed through so quickly, it was a bit blunt, I suppose. And some people, like my sister has a cafe, and she has workers who do 3 or 4 hours a day, casuals, and suddenly they were getting $750 a week, and they were probably getting $200 before. So it's changed, and it's been tamed a little bit. Not an awful lot, I think. Still, there's some areas there. And look, as far as I'm aware, and I can be corrected, and people can put their hands up or they can unmute and ask me questions at any time. I thought that they might make some special provisions for Victoria, given that we're under, such terrible circumstances at the moment. But as far as I'm aware, they haven't, and it's all going ahead as planned on a national basis. I was reading a bit about this today, and I'm not really sure that I 100% understand it, so I might have to do a bit more reading on it. But there's new provisions that are coming out in the new bill on JobKeeper, and one of them deals with reasonableness. There was a case which I'll talk about, and it's really about they're changing the provision or the section 789 GK, where a JobKeeper enabling direction given by an employer it doesn't have to be reasonable. It has to be. It doesn't have to be complied with if it's unreasonable in all circumstances. They haven't said a lot about it. There's not a lot of commentary about it, but I think what they're doing is softening the whole directives regime about giving employees directives. And I'll do a little bit more research on it and come back to you on it again. But I think part of the reason it got up, I might just move my.
I can see myself and I can't see my PowerPoint, which doesn't help anymore. I'll put you down there. That's it.
So the employer directions, there was a couple of cases where it was applied quite unfairly. So this whole provision is designed to perhaps counter when, if it's applied in a blanket way, that it has a disproportionate effect on some employees other than others, compared to others. But again, there's not much out on it yet, and I'll find out a bit more about it and let you know next time. I want to talk about this case. I talked about it last time, but I think it's really interesting because consultation is one of those areas that is getting a lot of attention from the Fair Work Commission. This was a case where they decided that the redundancy had been decided before the consultation had actually occurred. The employer had failed to discuss measures to avoid or reduce the adverse effects of the changes on employees, and was found to be an unfair dismissal. So it was a very interesting case around, and I'll talk a bit more about it. Consultation provisions are held in, are contained in almost all modern awards, and I think the issue becomes, it's usually held in the major change provisions of the awards. So the question then becomes, what is a major change? So if you've got 1,000 employees and you're making 2 redundant, is that a major change? If you've got 6 employees and you're making 2 redundant, is that a major change? So again, it's very fluid, but the Fair Work Commission is looking at it very closely. This is again part of, I think, some of the refinement now of stand downs and of JobKeeper. Here, what happened was the Commission told the employer was Ideal Acrylics, that they really were very unfair to one employee. Basically, they stood him down without any pay and kept all the other employees employed. So they said that really wasn't fair, that they needed to share the burden of the pandemic-affected consequences across all the employees. They couldn't just pick one employee and stand them down and keep everyone else working. He was stood down under the Fair Work Act provisions. You may remember, those of you who've seen earlier seminars, that before the JobKeeper enabling directives came in, unless there was a clause in your contract or in your modern award or enterprise agreement, you could only stand people down under very strict circumstances. And this is what they were. They were as an industrial action, a breakdown of machinery, or a stoppage of work for any reason that the employer can't be held responsible. What this person argued was that A, there wasn't a stoppage of work, and there wasn't a stoppage of work, and he could have been usefully employed elsewhere. But the employer chose just to stand him down and keep other people working. Deputy President Anderson, she agreed that this particular employee's work, the circumstances where he was stood down didn't constitute a stoppage of work within the section of within the meaning of 524, and that the employee said that his employer failed to consider reducing the hours of others so they could distribute the remaining work amongst everybody. And Deputy President Anderson went on to say it's entirely legitimate, obviously, for business owners to make difficult decisions regarding these difficult times, but their implementation should be conditioned by a principle of fairness. They shouldn't just pick one person and stand them down. So she said, instead of implementing a system of fairness, they chose to impose the entire burden of the reduction of labour on one employee while retaining the other employees. A fair approach would have been to apply it equally. So it was inconsistent with the Fair Work Act, and compensation was paid. Not a lot of compensation, but compensation was paid. Again, I'm finding it really interesting how closely the Commission is looking at how these decisions are being made. This is another redundancy one we'll talk about. This was interesting because, again, it's very challenging to make someone redundant and have an ulterior motive. You've always got to say, you think to yourself, how am I going to answer these questions if I'm up in the witness box being quizzed by a very fine, sharp mind of a commissioner or a federal circuit court judge or federal judge. So in this case, an employer restructured a senior manager out of his role and didn't consider him for a new role because he was considered an underperformer. But they found it was unfair dismissal and compensation was awarded. In short, there were two state management roles. They got rid of the two and made one. But the applicant in this matter was not considered for the new role. Deputy President Dean accepted that that was a redundancy, that the collection of duties as senior manager before didn't need to be done by anyone anymore. And those of you who have been to some of my seminars where I've gone through what you need to consider for a redundancy will know that is one of the key tests you need to meet. However, that there was evidence, undisputed evidence, this applicant had the skills and experience to take on the new role. What seemed to be key was the relationship had broken down between the parties, and they just didn't like each other, or more importantly, the decision maker didn't like the applicant. He said, I wasn't getting a return on my investment. I couldn't communicate. The relationship was coming to that breaking point between us. So basically, he picked the person he didn't like and made them redundant. What was held in the end was it would have been reasonable in all the circumstances for that manager to be redeployed within the employer's enterprise. So the Deputy President said that she was satisfied that his dismissal was not a case of genuine redundancy and awarded almost $18,000 in compensation. So once again, and I talk about this a bit, let me have a sip of red wine to keep my energy. You need to have criteria that are defensible. You need to have either a matrix where you can show the skill sets and how you've selected someone. You need to have compared resumes. You need to have something that's objective, that's defensible, that you can then turn to if you're questioned. This is the failure to consult. Again, this is the case I was talking about earlier. This was where a young woman who was a clerical assistant was made redundant just days before the unveiling of JobKeeper, which is sort of a bit incidental. But it was important that if they had gone through the consultation process, she would have got JobKeeper, was what the Commission was particularly peeved about, I think. They held that they failed to comply with the consultation requirements in the Clerical Assistance Award. I've talked about this case, so it sounds familiar, but I sometimes think, well, it takes me sometimes a few readings of cases to get the gist of them, so maybe that's the same with others as well. They said that if they had have consulted, she would have got JobKeeper. They said that the employer apparently told this young woman she'd be better off financially if she applied for JobSeeker. They asked her if she had any questions, comments or suggestions, but she didn't. But, you know, I think they just sprung it on her, from what I've read, and then said, we're going to make you redundant. Have you got any comments? The Commission said, that's not consultation. That's coming to her, the fait accompli decision made, and then asking her if she's got anything to say. She said that she would have accepted reduced hours if they'd offered it as an alternative. Deputy President said that the employer did not comply with the consultation obligations under the award. Merely asking employers, do they have any questions, comments or suggestions, just doesn't cut it. So this is the whole world of JobKeeper, redundancies under JobKeeper, changes to JobKeeper. I reckon we all need a break from JobKeeper and COVID, so let's go on to restrained trade. I think this is really interesting because I've always held the belief that a restrained trade in an employment contract is almost unenforceable. Those of you who work in this space will know that there's a tension between a person's right to earn a living and the employer or the former employer's right to protect their legitimate business interests. And generally, the courts are reluctant to stop someone earning a living. So restrained trade clauses tend to be read down. They tend to be almost null and void, because, you know, it's very difficult to say to someone, you can't work, you can't ply your trade, and you can't earn a living. And it also goes to the differences in power. Like you've got the employer, a business, an entity up against a person who is trying to earn a living. I learned this on the weekend or last week, and I found it really fascinating because I've actually got a similar case on foot at the moment where the Supreme Court of Victoria, it's a 2017 case, restrained an IT specialist from being employed by a competitor for a period of 4 years. That's a long time. He was unable to ply his trade for 4 years. So what happened was that Mr. Palmer sold his 40% stake in the business, Southern Cross Computing, to another company, Ingenio. That agreement was pursuant to shares which were sold for a value of $3.5 million. So for $3.5 million, he sold his share in that business. As part of the agreement, Mr. Palmer, who'd been an employee for a long time, so 15 years or so, agreed to remain in the business as an employee, and he entered into restraints. So he would have entered into a restrained trade in the sales agreement and a restrained trade in the employee agreement, which he would have entered into, hopefully, upon commencement of his employment. At the time of the hearing, it was uncontested that Mr. Palmer had been plying his trade elsewhere, that he had been working for a competitor. The central issue for Justice McDonald was whether it was reasonable for Mr. Palmer to be restrained from working for that competitor. I found it really interesting that it was found that it was reasonable. The maximum 4-year restraint, which was in the contract, was upheld. And the factors that were considered included Mr. Palmer's lengthy service. So he was a long-standing employee who knew the business inside out, would have known all the clients, all the secrets, all of the business of this business. That the restraint was a term on an agreement freely entered into by Mr. Palmer's company, and importantly, that a substantial amount of money had been paid by Southern Cross Computing in return for the terms of the agreement. So in turn, basically, for $3.5 million, Mr. Palmer agreed not to compete. So again, I think it's really interesting that, again, they look at, I think the courts look at, you know, jousting between businesses as fair game, whereas jousting between a business and an employee, less than fair game. So they were really quite comfortable to find the restraint was reasonable. And he concluded that they were entitled to an order, that the company was entitled to an order restraining Mr. Palmer from having any involvement at all in the competitive business. I just think it's really interesting when you're doing restrained trade clauses to be mindful of these sorts of factors. The takeaway from this, which I've sort of said, is while a court would be unlikely to find a 4-year restraint against an employee reasonable, this is not the case for restraints given as part of a commercial transaction. In the latter scenario, courts are far more likely to hold parties to their commercial agreement, particularly if a large sum of money has changed hands. I think I have another case, but I must have gone in there. My husband must have taken it out. The other case I was going to talk about, and I'll just talk about it verbally, is a case where a person tried to get a restraint of trade. Let me just think about the facts. It's the idea that if an employer repudiates the contract or somehow else engages in, here we go, it's here. Where was it? Here it is. That restraints of trade and every employee are not enforceable in a repudiated employment contract. This is really interesting. So again, I've said that usually an employee can't, it's really read against the employer, against the company. But in this case, it was definitely read against the company because they, in fact, had breached their own employment contract. So what had happened was that this particular employee had bonuses written into his employment contract, as well as strong restraints of trade clauses if he left. But the employer breached their contract of employment. They refused to pay the bonuses, or they changed the contract unilaterally. So if an employer repudiates the contract, An employee can either accept that repudiation by saying, you don't want to be bound by this contract anymore, so I'm accepting that and I leave, or accept it and say, I accept your change to the contract. In this case, the employer said, you don't want to be bound by the contract, you've agreed to pay me bonuses, you're changing the contract, I will now leave and not accept that change. So what happened is obviously he then went out on his own, and they tried to uphold the employment, the restraint of trade in his contract. The court said no. It said you repudiated the contract. You can't then rely on terms of that contract because you've repudiated it. So they said, in our opinion, the judge, because remember this was an appeal decision, so the judge in the first instance did not err in concluding that the employer should not have injunctive relief, which it sought. Our overall mission is that it must fail. Their claim must fail. And the reason was that, like in equity, the law of equity, you've got to come to a legal matter with clean hands. You can't have done something wrong, like repudiated the contract, and then seek to rely on terms of that contract later on. You've breached the contract. So again, it's very interesting law around restraint of trade. It's complicated law, and it sort of creeps into the whole world of commercial law. So at the moment, I'm partnering with another commercial lawyer in town on the matter, but it's very interesting law. So we go to the end. Oh, we go. Restraint's not enforceable yet. Here we go. I've got that. Oh, I'm going the wrong way. Sorry about that. I think the important thing to be aware of, or what I say often, is when in doubt, get legal advice, not just because I'm a lawyer, but I think when you're in doubt, employment law is complicated, get legal advice, get it early and get it often. I suppose I also want to talk about a couple of what people say about me. I've been here for 12 months now, just over 12 months. And I opened a law practice just before COVID, so that was all fun and games. But there's a couple of lovely testimonials that I've received recently. And one's from a local accounting firm that said they recently engaged me to provide ongoing advice, and they found my advice to be concise, extremely helpful, and they recommended me highly to their colleagues. The other one was from a plaintiff. This was really a lovely one, where this guy had been treated really appallingly by his employer. It was quite a long testimony, but I'll just cut out this last bit. And it says, I have no doubt that without Rosa's professional advice and persistence, I would still be battling for my basic rights as an employee. She was worth every penny, and I would highly recommend her to anyone needing workplace relations legal advice, which was very nice thing to say. Where can you find us? Well, you can find me at wirlaw.com. You can find Tim at Lome Vineyard or at Breast Vineyard. And I think Tim might have a little sweetener. If anyone mentions, I haven't told him this, but he might have a little sweetener. If anyone mentions this session, he may sort of give you an enticement to purchase some of his wines.
Well, happy to do that, Rosa. Though you have caught me by surprise a little bit, but we're happy to offer wine purchases from our website and a 10% discount and free shipping, and that's wherever it may be. So I'd encourage you to have a look on the website, or both websites, for Lome and for Breast, and see what's there. If you have any questions, feel free to ring me. The phone number is on the website and or websites, and we're happy to assist.
If anyone's got any questions now, does anyone want to unmute their microphones and ask either a wine question or a legal question? Pauline, you're typing away there. Are you typing to me or? No? Is anyone in the chat? Technology is a bit baffling. You're muted, Pauline. Unmute yourself. Someone said to me, that's the phrase of 2020, unmute yourself.
Yes, it is, Rosa. No, I was just writing down some details about yourself and the winery as well. Can I just say I found that very interesting. I don't know whether you know whether the decision that you read on the restraint of trade for the 4 years, was that just with that competitor?
Oh, I don't know, but I would say that it was a broad I've got the link to the case, have a look, but it certainly was with that company. But
Yeah.
reading it more broadly, I would say there's a restraint of him competing. And, you know, there's a lot of consideration. $3.5 million he got to be restrained. So that's certainly enough to keep him alive for 4 years while he's taking out his restraint. But it's really interesting because restrained trade, as you know, Pauline's a very experienced industrial relations person, is tricky.
A complete waste of time, really, usually.
Well, yeah. Except if the employer's repudiated the contract, that'd be nice. Then you can get it sort of, you can say, well, you can't restrain me because you're the one who, you know, mucked us all up. Interesting. Yeah. I think we've been over JobKeeper and stuff, so I might talk about other things for a while. Has anyone else got any other questions? Carol or anyone else? I can only see Pauline. So everyone's very shy. There's no videos. No? Any wine questions? No? Well, that's it. Let's have a toast. Thank you for coming, Tim.
Yeah, thank you, Rosa.
I hope you all enjoyed that. If you've got any questions, either of Tim or me, please don't hesitate to make contact with either of us, both of us. And if there's anything that we can help you with in any way, then please let us know. Cheers. Have a lovely weekend.
Thank you.
Thank you. We've now got to work out how to get out. End there. Oh, there was a chat there. There's somebody.